Supreme Court of India 2023 SCC Online SC 1358 Abhishek Sharma vs State Government of NCT of Delhi decided on October 18, 2023 Facts. Abhishek Sharma convict/appellant and Mandeep Kaur deceased were colleagues. She found engulfed in flames, passed away on 03 October 2007. Convict/appellant was arrested. A challenge was presented under Section 302 IPC. Convict/appellant was found guilty and convicted under Section 302 IPC by trial court. Judgment of the ASJ was affirmed by the High Court. Held, a case involving multiple dying declarations. The primary requirement for all dying declarations is that they should be voluntary, consistent and reliable, and that such statements should be in a fit state of mind. When inconsistencies are found between various dying declarations, other evidence available on record may be considered for the purposes of corroboration of the contents of dying declarations. The statement treated as a dying declaration must be interpreted in light of surrounding facts and circumstances. Each declaration must be scrutinized on its own merits. The court has to examine upon which of the statement's reliance can be placed in order for the case to proceed further. When there are inconsistencies, the statement that has been recorded by a magistrate or like higher officer can be relied on, subject to the indispensable qualities of truthfulness and being free of suspicion. In the presence of inconsistencies, the medical fitness of the person making such declaration, at the relevant time, assumes importance along with other factors such as the possibility of tutoring by relatives, etc. DDI have been recorded in the third person, that is to say, that ASI Anup Singh PW, 16 had reported on the incident. DD2 is, in fact, an entry in the medical legal inquiry register made by Dr. Raj, PW 8. It states the presence of burn injuries and says that the same was caused by Abhishek, which, arguably, is insufficient. There is no particular identification of the convict appellant, nor is there a mention of the means through which the injuries were inflicted. Petrol, DD3, no attempt was made to have the same made before a doctor or magistrate. The deceased had been administered treatment for her injuries. However, it has not come forth as to the nature of treatment and what kind of medicines were given to her. In the absence of a positive statement by the medical team responsible for her treatment, it cannot be stated, with certainty, that the medicines administered had no effect of impairing the mental fitness of the deceased. Therefore, with the cloud of doubt surrounding DD3, it is but natural that the court looks to other circumstances and evidence to satisfy the requirement of the statement made as being true and voluntary. DD4 witness denies ever having made any statement to the police. Such a statement in no manner can be said inculpatory towards the accused, for it is lacking in particulars with regard to the person mentioned therein, i.e., Abhishek Sharma, and having no linkage for the same which could lead to the accused person. Lack of independent corroboration, particularly when the person making the statement is the mother of the deceased. The court cannot rule out, to a positive degree, the role played by a sense of loss and possibly even anger, to rely on such statement. The convict appellant was not seen at the spot of the crime, nor has the last seen theory been invoked by the prosecution to establish that the deceased and he were together at the time and place of the incident. There is no evidence on record to show what transpired in the investigation of the police from the time of DDI when, allegedly, the police came to know of the convict appellant having committed this crime against the deceased and when he was finally arrested at 8 p.m. Inconsistencies to be dotted throughout. The prosecution did not find it fit to examine the brother, which could have thrown light upon the deceased's relationship with the convict appellant, among other essential facts. Apart from the alleged dying declarations of the deceased, there is no evidence on record to point to the guilt of the convict appellant. Nothing on record indicates the ownership of a vehicle by the convict appellant, any disagreement or animosity between the convict/appellant and the deceased, that is of such an extreme nature as to set her on fire, any connection between the convict/appellant and the inflammable substance used to kill the victim, such as the record of purchase or statement of any person to show such substance to be in possession of the convict appellant, etc. These factors and the fact that the crime in question occurred at an open public access place cast doubt on the prosecution case. Gaps unexplained in the prosecution case, which cast sufficient doubt as to leave the case short of the threshold of beyond reasonable doubt. Appeal is allowed.